Hi there, it's Kaushik Ranchod and welcome to Ranchod Law TV. Today we're going to talk about waivers, different types of waivers here. And at our law firm, we have a focus on waivers. So there's different types of waivers. There's the I-601A. That's primarily for what's called unlawful presence if you entered without a visa and you just overstayed. There's the I-601. That covers different types of criminal issues. Then there's the I-612 for J1 waivers. Now, what all of these have in common is hardships that you have to demonstrate to your qualifying relative. Depending upon the type of case, is going to depend upon the relative, but for instance, most of them include hardship to the U.S. citizen spouse. Depending upon the type of waiver, might also be parent, U.S. citizen parent or permanent resident spouse, or also possibly, depending upon the waiver, U.S. citizen or permanent resident child. So I have videos specific on those specific I-601A, I-601, J1 exceptional hardship waivers if you want to go into the details of the qualifying relatives. Today what we're going to talk about specifically is how do we get these waivers approved. I'm going to share with you some of my inside secrets of how we are able to get this approved and what we do in our office to get a hardship waiver approval in these different types of cases. Now, every case is unique. We can't guarantee an approval, but I'll share with you what we did to get our cases approved here. What happens a lot of times is what we've seen is people who went to notarios or had a case prepared by an attorney who didn't prepare their case thoroughly, or they did it themselves and they come in with a denial. And what we have to do is repair that denial, either because the case was not prepared thoroughly or was a sloppy job, or for instance, a notario didn't give the correct advice in the case. You know, they're not licensed to practice law, notarios. So one of my first cases, this was like about 15 plus years ago, where the notario told the client that their spouse should go back to Mexico to process their case. In that case, it was bad advice. So then we had to file for I-601 waiver in that situation. Back then, they didn't have the I-601A. Now there's the I-601A where you can apply for that, get that approved in the United States. So we were able to get that I-601 approved, but that was a costly mistake that notario made. So one of my favorite things is to get those kinds of cases fixed and repaired. Of course, it costs usually more money and time for you to repair it, so you want to get it done right the first time. What we like to do is to just build a very thorough case by looking at all of the different hardships in your case and evaluating all of the different hardships that may not be apparent to you. Really, the way we're able to do this is because of our many years of experience. We're able to really evaluate what a hardship may be to you that you may not think would be a hardship. An example of this would be a case where we were able to make a hardship argument, if you will, because we were able to identify emotional eating in the hardship. And our client didn't think that this was a hardship, but it turned out it was, because whenever she was anxious, she would turn to emotional eating, and we had a psychiatric evaluation done which confirmed that. And based off of that argument, we were able to get the case approved. So that's where someone who's trained in hardship waivers is going to be able to identify hardships that you may think you don't have a case when in fact you do. And this really takes a lot of time and effort on the attorney's part to really look at all of the different factors of the hardship that may not be apparent to someone who's not well versed in this area. So in that situation, that was an example of an I-601A case where there was unlawful presence, where they entered without a visa, overstayed. And in that situation, we also explain hardship to the spouse if they were going to be separated as well. Now let's look at another situation. I'm going to talk about a J1 exceptional hardship waiver. Here, again, the client wasn't able to realize that they had some exceptional hardship. In this situation, we're taking their child to the doctor again and again every time they had a cold. So we immediately picked up on this and evaluated the medical records, and we were able to make an argument here off of the fact that they were having chronic respiratory infections based off of this situation. They weren't able to identify it, but we were able to make an exceptional hardship waiver argument that was approved. And that always gets us excited. We know that cases are never based off of typically one argument. It's very rare that people have the slam dunk argument. So we look at the totality of the circumstances, and if many of you who've been watching my videos should know this by now, but we like to throw in as many arguments as possible to demonstrate either extreme hardship for I-601, I-601A, or exceptional hardship for I-612J1 waivers. And what we look at financial hardship, we look at career hardship, we look at medical hardship, we look at mental health hardship, we look at the country conditions as well, and we try to tie in as many factors as we can to build the best case possible for you. Now, it's not just about knowing the law, it's about knowing the particular facts in your case and being able to build an argument off of that. One of the ways that we're able to communicate an effective argument is through a legal brief. So through a legal brief, what we do is we look at the statute and law governing the case, and we argue how your specific case meets the standards that are set forth by the law. This is really important. It's not just a statement. A lot of times people will think that they can just provide a statement, and you can just provide a statement, but it's getting harder and harder to get these cases approved, so you want to do everything you can to get a case approved. So that's why we like to prepare a very thorough legal brief that will make the best arguments that we feel are possible to make a case that will demonstrate exceptional or extreme hardship. So let's talk about some examples here. Another case study here. This was our client here in this situation. The client was from Mexico. He overstayed, eventually got married to the love of his life, and then she was pregnant. In this situation, what we argued is that she would lose her health care coverage. Co-parenting was really necessary in their situation, and also that this was just be financially burdensome for the couple, because if he was going to go back to Mexico, then she would have to take extended unpaid leave to take care of the child herself, and then she would also have to pay for childcare as well. So all of these things coupled together were creating a form of extreme hardship. Additionally, she also had a lot of family ties here. She had siblings, nieces, and nephews, and her parents. Additionally, she was also seeing a therapist for anxiety, so we talked about that as well. And we're able to tie in the mental hardship and the additional anxiety that this would cause. And that's how we were able to get that case approved. Now, what even made that case more difficult was that they had a criminal conviction as well, and yet we were able to get it approved. So I like to think that we know what we are doing here. I invite you to contact us to learn more, to see if your case does qualify for a waiver. Each case is unique, so we have to evaluate it to determine whether or not your case would qualify and if it is eligible to be able to apply for a waiver, because not every case is going to get approved, or maybe you shouldn't apply for your case because it doesn't really meet the requirements. So I want to thank you for taking the time to watch this video. You are amazing, and I invite you to just continue to watch our videos so you can learn more, get educated, make the right decisions, and stay amazing. Bye.